Welcome to everybody in the room. My name is Vince Geralman. I am the Life Sciences Law and Policy Center Director here at Berkeley. And before that, I was in your shoes here not too long ago in this very classroom. And after my 1L years, I did OCIs, as many of you have already gone through. And when I was doing OCIs, I applied to Cravath. And when I applied to Cravath, I got to meet Dave Kappos, who is on the call right now. And Dave is also an alumni of this school. And Dave and I shared a love of New York. We talked about rats commuting during my callback. We talked about our love of food and our love of intellectual property. That eventually got me an offer to work at Cravath, and I worked there under Dave in their IP practice group. And we did everything under the sun, including some stuff on wearables. And now that I'm back here, I really wanted to bring in Dave and the rest of this amazing cohort of people to give a talk on what is a really pressing, interesting intellectual property, interesting privacy, interesting life sciences issue, which is wearable technologies. So we have an amazing group here. I'm going to hand it off to them to take it away from here. So Stan, have you take it away.
Thank you. I'm Stan Weinstein. I'm doing the introduction. And good afternoon, everyone. Good to see everybody. Welcome to They Know If You've Been Sleeping, Ethical and Cybersecurity Aspects of Privacy Risks with Health Trackers. There have been published reports of bad actors finding openings to accomplish nefarious results when an unsuspecting or careless target, perhaps asleep at the switch, finds out to its dismay that it is vulnerable. Many years ago, a mechanical device called a pedometer attached to your belt was supposed to adapt to the length of your stride to show how far you'd walked. Very useful, very standalone. Later, electronic step counters simply counted your steps as a measure of your fitness activity. Some companies would use such devices to encourage fitness of their employees, possibly intended to reduce healthcare expenses. To incentivize use, electronic badges might be awarded for steps per day or some other period, stairs climbed, or other activities. Seeing a potential market, other entities would sell such devices, and to promote them, arranging virtual competitions among users, thereby promoting interconnectivity. Health monitors are now widely used by individuals concerned with fitness, healthcare entities, employers promoting employee fitness, and others. But how vulnerable is such a monitor and the data it collects? And what are the lawyer's ethical obligations in advising clients in connection with such monitors? The data collected by such devices, even if properly handled, may yet be subject to many uses and misuses, as well as many laws and regulations addressing such uses and misuses, as are transmissions from such devices. These and related issues will be considered in this presentation. I will now briefly introduce our three excellent speakers in the reverse order of their appearance. Beth Burgin-Waller is chair of the Cybersecurity and Data Privacy Practice at Woods Rogers. She holds the CIPP US USA and CIPPE European Information Privacy Professional certifications. Beth was appointed by the Governor of Virginia to the Commonwealth's first Cybersecurity Planning Conference for local and state governmental entities, where she continues to serve the Commonwealth. Ceren Canal Aruoba is Managing Director and Co-Lead of Consumer Protection, Product Liability, and Environmental Practice at Berkeley Research Group, LLC, in Washington, D.C. She also serves as Vice Chair of the Advertising Disputes and Litigation Committee of the ABA section of Antitrust Law. David J. Kappos is Co-Chair of Cravath, Swain, and Moore's Intellectual Property Practice, is a former director of the U.S. Patent and Trademark Office, and has received many awards and other recognitions. Dave, the floor is yours.
All right, thanks, Dan, and good afternoon. Great to see so many students they're at home in California, in Berkeley. As Vince says, I sat in your chair a few years back. And thank you for spending time with us this afternoon. I'll just give my brief commercial plug to say, please come interview at Cravath. Love to have you join our team here, and we could talk about food, love of intellectual property. I won't guarantee any discussion of small rodents or anything like that, but it's great to see everyone. So look, as Stan said, wearables essentially are everywhere. The technology has rapidly become part of our daily lives, including everything from smartwatches to fitness trackers to medical grade wearables, with nearly a third of Americans using some kind of wearable health device. The latest smartwatches can perform electrocardiograms, measure your blood oxygen level, functions once limited to clinical settings. Wearables aren't just pedometers anymore. They're becoming quasi-medical devices providing health insights. But with great power comes great responsibility and ethical challenges. These gadgets collect health data about our bodies and activities that can be as sensitive as medical records. But most of this data is collected outside a doctor's office, outside a hospital, meaning it isn't protected by laws such as HIPAA, our major healthcare protection law for health-related information in the US. Under HIPAA, information is PHI, personal health information, only when created or received by covered entities or their business associates. Health data gathered by consumer apps or devices outside of clinical care is usually not HIPAA. So, as we introduce wearables, we have to flag that data privacy and ethics are major concerns. The question we'll explore here: how do we enjoy the benefits of wearables while safeguarding individual rights and sensitive data? Without strong safeguards, the data empowering personal health insights could be misused, compromising user privacy and trust, and this in turn sets the stage for digging into those privacy risks and legal ethical frameworks evolving. Wearables pose significant privacy and data collection challenges. So first, consider the sheer volume and intimacy of the data these devices collect. They're logging your heartbeat every second, your sleep patterns every night, your GPS coordinates all day. All of this creates a comprehensive picture of you. And this data doesn't just stay on the watch. It's synced to the cloud, to the manufacturer's servers, even to a whole ecosystem of apps. And that's a treasure trove of sensitive information, vulnerable to misuse if not treated carefully. Now, when users are caught off guard, it can create legal issues. As an example, health and wellness company Whoop, whose wearable devices track and collect users' health metrics, was sued in August 2025, just about 6 months ago or so, with plaintiffs alleging the sharing of in-app activity and health metrics with third parties without authorization violated their rights. Security is another concern. Any large database of personal data is a honeypot, a target for hackers. If a breach occurs, highly sensitive personal information could be exposed. And unlike a stolen credit card, a user can't reset their DNA easily or at all, or hide health patterns once they're leaked. This raises the potential stakes of a breach quite significantly. Even intentional disclosures can create security risk. So take, for example, Strava, fitness app that published users' running and cycling routes. In 2018, when Strava published a global heat map of user routes, it inadvertently revealed the locations of military bases and personnel around the world, highlighting patrol routes and sensitive facilities via aggregated activity data. Not good. Many assume health data is protected by HIPAA. I mentioned that briefly before, but if a consumer on their own uses a fitness band or a health app HIPAA does not apply. So consumer tech companies operate outside the traditional health privacy regime and generate general consumer protection laws and contract laws are often the only thing forbidding companies from doing things like selling de-identified health stats or using data for targeted ads. In the HIPAA void, US states are stepping up their regulatory responses. California, of course, leads in that regard, but other states are in the action as well. Washington's My Health, My Data Act bears on this. New York's Health Information Privacy Act is applicable. And then, of course, in California, via the CPRA, we now have a label for sensitive personal information, which includes health data and biometrics, and gives consumers the right to limit the use and disclosure of this category to what's necessary to provide requested services. Many other states have their own comprehensive privacy laws that include coverage for data collected by wearables. What you see as a result is a patchwork of laws that can create confusing compliance regimes for lawyers advising companies engaging in nationwide commercial efforts, especially where there's been little judicial clarity from case law. Lawyers may feel conflicted on what advice to give. However, the model rules provide some guidance for those situations. I know Beth's going to talk about those more later. I'll just mention Model Rule 1.1, requiring technical competence. Model Rule 1.2, forbidding assisting unlawful conduct, meaning counsel can't assist a client strategy that clearly violates these statutes. Model Rule 1.3 provides guidance on advising remediation, noting that lawyers should report up to higher authorities if an organization, if that becomes necessary. And then Model Rules 4.1 and 8.4 that require lawyers to avoid making false statements of material fact or law. At the federal level, as I said, we don't have a law covering wearable data. Instead, much of the enforcement falls on the FTC, Federal Trade Commission, under its power to regulate unfair and deceptive practices. For example, in 2021, the FTC finalized a consent order with Flo Health, a fertility tracking app used by more than 100 million consumers, requiring affirmative consent before sharing health information and independent privacy reviews. And state attorneys general have taken action against companies for misusing health data by leveraging both consumer protection and other sectoral laws. As an example of that, in 2020, the California Attorney General's office obtained a settlement against Glow Inc. over privacy security failures in a fertility tracking app, including a $250,000 penalty. On a global level, the EU's GDPR is, of course, the dominant force. And under GDPR, of course, information about health, including data from wearables, is considered in a special category of data, and it has strict rules. Processing generally requires explicit consent in this area. If a US wearable company has users in Europe, they must comply with these requirements or face hefty fines. For example, when Google bought Fitbit in 2020, EU regulators only approved it after Google pledged not to use Fitbit health data for advertising and to silo that data for at least 10 years. This gives you a sense of how seriously regulators can treat wearable health data. So who owns your data? Beyond privacy and data protection laws, data ownership and intellectual property are also important to consider in the context of wearables. The question of who owns the data is actually pretty tricky. If someone wears a device that captures heart rate and steps, intuitively, we might say that information is theirs. But legally, once the data is uploaded, the wearable company's terms of service often grant a broad license to use that data. As counsel, there's a clear ethical imperative to ensure ownership is not a shell game by advising clients on clear disclosures and granular choices. Model Rule 1.1 and 1.2D caution against designing consent flows that bury uses, and rules 4.1 and 8.4 prohibit mismatches between practice and policy. The best practice, therefore, is to advise clients to avoid so-called dark patterns, capture consent provenance, and align retention with stated purposes, all to ensure that privacy practices being sold to your consumers are what is actually going on behind the scenes. And with that, I'll turn it over to Stan to advance to the next slide and onward.
All right. Thank you, Dave. I'm going to take from where they left a little bit and then move us into thinking about litigation risk in this area. So I work with a lot of actually academics in this space and assessing what the potential harm to consumers are once this kind of litigation risk materializes itself. Obviously, there's risk with many of the things that they mentioned, right? Related to the product itself, the way it's designed, the way you abide by the rules, governance rules, and so on. But what happens once that data kind of gets into the hands of people who weren't supposed to have, or really from the consumer's perspective, they did not want that data to be shared. So in this space, I think there are two ways to categorize the risk once this comes to the litigation. But obviously, there are agency like SEC and others. If you're a publicly available company, might bring cases as well. But in this space, there are two types of issues related to data and variables, and many of these on the screen kind of hint at that a little bit. So in one space, there are what we would classify as data breach cases. So you gather the data you're using internally, and somehow someone infiltrates your systems, either have access to it or gets the data, and that's one part of the risk. Then there is what we would call data privacy related to tracking information, and this is where consumer consent that they mentioned comes into play. Consumers, when they use the products, they check a box, a disclosure, if you will. When they download the app, they accept certain terms of use. But when they do that, what did they really consent to? And there are some of people going to talk about what that means in the space. But so there are two types of information within the data breaches and within the world where the information that the consumers provide, where there's consent and what did they actually ask the company to do with the data. So if you move forward a little bit, I want to kind of put us on a framework using a case that Dave mentioned, Flo Health app. This is a women's health app. It's a popular one, it's also an international app. So I wanted to mention two things that are interesting, two things that happened in parallel that are interesting. One is the FTC versus Flo Health litigation that has happened that they mentioned. So this again was related to, the key here was that what the company disclosed about what they were doing with the data that they collected. And the big thing was that in their marketing materials, what they were communicating to consumers is that they were safeguarding the data and they were not sharing with anyone. But lo and behold, like many other mobile and digital products, they were using what I will call third-party analytics apps. And this happens a lot. They are, Facebook, Google-related third-party apps that kind of Google Analytics that help the companies keep track of their online traffic, if you will, and provide valuable information to companies. When the consumer itself agreed to that use of service for that app or service or website, what does that mean about a third party? And specifically here in this case, FTC was not happy that they didn't, specifically telling that they weren't going to share with a third party, and then they did it, even though if only meant that company use was was allowed, is in only Flo Health used. Again, there were international implications of this as well, because it was an international. But I do want to point out the few things from the FTC settlement. I think it's important to point out because this ties into a few issues that I want to mention down the road. One is FTC required Flo Health to acquire affirmative consent. And we're going to talk about consent a lot because that's kind of the hallmark of when it comes to data, but it's not enough from FTC's perspective that consumers agreed to use the app, but did they actually affirmatively consent to the idea that their data could be shared with others? So they required that as part of the settlement. The other one is that's interesting is, they basically instruct third parties to delete their prior data. And this seems pretty easy and intuitive on its face, but I guess there are implications in terms of you need the infrastructure to be able to do that, right? As Flo Health can only instruct, but they really don't know probably what that information is being used once it kind of gets out of their hands. So it's important to build that infrastructure early on, or have some mechanism or governance around that data that for any company that's in this space to think about before actually launch themselves. And then the third one is Flo agreed to basically an independent review so that they're compliant. So it's not just one-time thing. They're going to be under supervision for a few years. Generally, I think, for a few years for FTC to make sure that they're abiding by that. I want to kind of follow up by generally these government cases are followed by what we call class action cases. So individual consumers get together, which is actually pretty unique to US in many ways. It's a mechanism that allows consumers to get together to sue the companies for violations that they think are illegal, and that generally is empowered by some of the laws, especially like in states like California, as they mentioned, that have specific laws related to privacy and medical information, like CMIA, CIPA, and so on. So in this case, right on the steps of the government case, a group of consumers sued not just Flo, but what the third parties as well that they were sharing the data with. The important thing here is that Flo settled for a large amount, and the third parties settled for larger amounts than Flo did, but Meta stood out and went to trial and lost. So this case is an interesting one to keep an eye on what happens in terms of damages, because as I will mention in a second, the biggest issue in these cases in terms of company liability and so on comes from the penalties, the civil penalties that are granted under these laws. So it's not just what is the damage now that you lost your data or value of data, but did the company have, how many violations the company had? And you can imagine there is no definition of violations in law. So every screen, every session could be counted as one. And if that's the case, that adds up to a lot of money for in terms of liability. So if you move forward one more, right. So I wanted to mention 3 key points when it comes to learnings from the Flo Health litigation, but in terms of how to think about this space when we think about liability. The very key question that comes up in these cases is that what is considered personal information, what is private information, and what personal private information is shared, right? And there are definitions of what personal private information is. If you Google online, you will find few. But when it comes to law, there is not one law that kind of is everything falls under. So it becomes a little tricky to think about what information of mine do I consider personal private under the law. And the other one is de-identified data. Again, they mentioned this. Many health information is de-identified. They, name, address are removed, and they're just a unique numbers associated with that person. But there are ways to unde-identify the data or kind of bring different pieces of information to link it to an individual person. So that those issues are critical to think about when you are storing that data, when you are sharing that information, even if you have de-identified. the second biggest issue, consent. Did the user give consent, and what did they really give consent to? For Flo Health, it was more about, I mean, it was pretty technical. Was it within the information shared between the third parties and Flo Health? What information within that basically script of code was identified, which are called SDKs, which one was, which information there was personal or not? But generally speaking, the big question is, when a consumer downloads an app, we all do, right? When we agree to use our Apple Watch or any kind of health tracking app, there is quite a bit of actually literature, academic literature, that studies the disclosure world of things among consumers, and that suggests that consumers do not really read much. I mean, that's why they force you to kind of scroll down to the bottom of the page to actually get the accept button or okay button, consent button clicked on, because they know consumers have very little tendency to read the details and even understand, even if they wanted to. So within that world that we are living in, what does consent mean under the law? And it's not black and white in many ways, but that's a big issue. That's a battlefield, if you will, when it comes to consumers' understanding of what they're checking in or not. And then obviously there's the monetization part that they mentioned, right? Like, what is happening to this data? Who is, gaining from this data? Because most of the time, my experience tells me that companies are not very, they think they're sharing the information in exchange for things like Google Analytics, monthly reports, some AI maybe based, information, future-looking information, but it's not always clear that the company knows exactly what they are allowing that data to be, monetized or done in when it goes to third parties. So it's important for the company to figure that out, and or maybe kind of not just go by the standard contract, but think about, what that implies in terms of litigation risk for them down the road. And lastly, if we move one more, I want to tie all those 3 points into the harm point, because in these litigation, eventually it goes to consumer harm, the quantification of it, what that means, right? And I guess there are 2 ways to think about harm. The harm that comes from, so one is in the privacy context, and this comes from, again, academic literature, the personal data. It is underlined by the belief that there is an intrinsic value of data, as in to you as a person, and once that's breached or lost or shared with someone, that intrinsic value is lost. There are counter arguments to this as well. One of the big ones is that for those of you who have studied economics in the past, maybe, or know a little bit about this, for there to be a price, for there to be some sort of a market, there needs to be a supply and demand. They kind of have to intersect to get at the value, the price, if you will. But you and I, and as individuals, cannot really sell our data in an open market. I can't really sell my name, social security. I mean, there are some places where I can sign up to maybe take surveys or something that pay me for that information. But in reality, it doesn't exist. So there is really not a legitimate transactional market when it comes to personal data. So it really handicaps assessing the value of data from an individual's perspective. Now, you can say that value actually is in aggregation, right? The more people bring it together, it's not really my name, but it's my profile, if you will. That's really important to marketers because that's what they sell. But that value is actually different than the company collecting it, because that rent is not really being internalized or captured by the company collecting that information. So it's important to think about what really intrinsic value of data privacy means and how it lives in the world of litigation. Also, I will point out that there is something called a term, maybe you all heard about this, it's called privacy paradox. So it's really hard to ask or elicit people's value of data directly. One reason is that obviously we ask it, if you survey individuals, if you ask people if they value their privacy, majority of them, if not all, say they do. But then they go ahead and then do things in life that kind of contradict that. They share their information online, they post information, they are not very clear. They don't have procedures to capture their information. They have Alexas and Siris at home. So that's called the privacy paradox, in the sense that consumers, while they say they value their information privately, they do act things that contradict that. So it's really hard to assess illicit privacy evaluation in a world like that. And then the last thing I think I want to mention is that in some of these cases, there's, plaintiffs or government actually goes after actual harm. And you can imagine what kind of an actual harm, and things that fall under this, like how much time did you spend mitigating the risk of the data breach? Obviously, you get a letter from the company. It asks you to sign up to a credit report monitoring service. So you have to spend time taking from work or your other stuff to manage that. There's obviously risk of future economic injury, as in someone might steal your identity and then eventually file a claim on your behalf, for example, from Medicaid, or same with Social Security numbers. And then obviously maybe there's like loss and suffering. So there are tangible calculations, but in most of these cases and environments, they are not the highest value when it comes to harm, because as I said, civil penalties up to 5,000 under SEPA can actually be millions, if not billions, depending on the data, on data shared, and the company that was sharing it. So the litigation risk and the exposure for those companies are pretty high when it comes to this. So I'm gonna pass this back to Dave to kind of wrap us up on this one.
Yeah, and I'm just going to now finish this part of the presentation before we turn over to Beth with some kind of summary wearables best practices. A core principle when thinking about best practices for wearables is user consent and control. It's about respecting user autonomy. Concretely, that means when someone sets up a device or an app, they should be clearly prompted about data sharing options, and those choices should mean something. Also, access and deletion rights are key, meaning best practices are to allow users to see the data collected on them, to delete it if they stop using the service, and to exercise correction and portability rights. Focusing on ethical duties, counsel should flag any mismatch between notices and actual uses. So as an example, if a wearable policy promises to provide the service only, but the client forwards health data from a wearable to third-party analytics or ad partners, require a pause, update notices, and obtain required opt-ins before a restart. That's the right practice. Counsel should also steer away from consent by obscurity, where key choices are buried in dense setting, pre-checked boxes or accept all bundles. Wearable companies instead should keep auditable consent logs and record who consented, when, for which purposes, via which user interface version, and proof of withdrawal, so the company can substantiate consent to regulators and counterparties if required. Companies should also consider privacy by design and strong security practices. Privacy by design means the company considers privacy at every stage of product development. For instance, if a new smartwatch feature wants to analyze voice samples for stress levels, the team should be asking, do we really need to send the raw audio to the cloud, or can it be processed on the device? Can we encrypt it such that even if intercepted, it's not decipherable? What's the minimum amount of data and the shortest time we need to keep it? These considerations help minimize risk. Now, ethically, lawyers should push for companies to test claims. For example, end-to-end encrypted. What does that really mean? Are we really doing it? Before they are made, and counsel should also confirm vendor contracts reflect actual data flows. Compliance and accountability, of course, go hand in hand with the above. Ethically, counsel should push companies to operate to the strictest common denominator, not the most permissive one. That means treating biometrics, precise location, and health inference as sensitive everywhere, using explicit consent as the global default, honoring deletion and portability regardless of jurisdiction, setting short retention defaults, and running impact assessments for new features. Lawyers should build in review gates for sensitive features and confirm that interoperability happens under license rather than through uncompensated copying. As a counsel, there are several best practices to keep in mind. First, if your client proposes a planned use of wearable data that lacks a lawful basis or consent, you should insist on a pause and remediation consistent with the obligations under Model Rules 1.1, 1.2d, and 1.13. Lawyers should avoid assisting false or misleading statements to partners or users or regulators concerning wearable data. And finally, it's all about balance. We all want the innovations to keep coming. Wearables can save lives, detect diseases early, help manage conditions like diabetes or hypertension more effectively, and generally empower people to take charge of their health. Those are huge positives we absolutely want to keep. The vision of personalized, data-driven healthcare is indeed incredibly promising, but it will be undermined if people lose trust in how their data is handled. So the industry, guided by us as lawyers, needs to earn and maintain public trust. That comes from prioritizing privacy, being transparent about what algorithms are doing, ensuring those algorithms are fair and accurate across different populations, and preventing misuse of data. So there's a bit of a summary now. I'd like to turn it over to Beth for some really great privacy and ethics comments.
Thanks so much, Dave. And first of all, I'm really excited to be here and to geek out with you guys at Berkeley, even if it is on Zoom. A couple of quick questions. One, how many of you, I can kind of see you in a teeny tiny little window up on our Zoom screen here. How many of you are wearing a Fitbit or a Garmin? Can you raise your hand in the room? Are you wearing an Apple Watch? Right? Okay. Yeah, it looks like we have a lot of folks who are doing that. You know, we do have a duty of competence, right, as lawyers, and I'm going to kind of flow through the remaining slides here that Vincent's going to share very quickly because, you know, speaking of duty of competence, you know, you're law students and you're in the room with these bright minds like Dave and Ceren and Stan. Stan in particular was very humble introducing himself today. You all don't realize that before he kind of retired into solo practice, he was lead patent lawyer at Lockheed Martin as a large defense contractor. He is a brilliant patent lawyer, and he didn't introduce himself, and he's always very humble. So I just want to make sure you know who you have to ask questions to this afternoon, in addition to alums like Dave today. You know, on the slides, you know, we are talking about the lawyer's ethical duties of competence, right? The idea of understanding that we as attorneys need to maintain competence and know exactly the benefits and risks associated with relevant technology. Vincent, if you could push forward to the next slide. We talked a little bit about Fitbits, right? At the beginning, we talked about the Strava data, the idea being that for those of you that are big time runners, you know, that there were Army folks basically running the perimeter of a clandestine military base out in Afghanistan. And because that data was uploaded into Strava, then everybody learned the location of that particular military base. And as attorneys, we really need to be cognizant of what it is that these devices are doing and what they are gathering. How many of you are following, I'm a news junkie, and this is also terrible morbid news, don't get me wrong, but how many of you are following the Nancy Guthrie case in the news? Any hands in the room? Anybody following that? Yeah. For those of you who don't know what I'm talking about the mother of Savannah Guthrie, who was kidnapped, right? Why am I bringing that up in this presentation? Well, I'm bringing it up because not for wearable, but at least for embedded device, right? Her pacemaker has come up in the news as a relevant source of information and tracking information, right? So the pacemaker, you saw, perhaps if you've been following the stories, the sheriff's department was reporting that the pacemaker last pinged with the iPhone, right, at 2 a.m. Around about when she disappeared, the day she disappeared. The other thing that I think is of interest when we think about wearable technology or embedded health devices is that, in particular, it looks like the police department was using a Bluetooth sniffer to try to see whether or not they could pick up the ping from her pacemaker flying low. And so why do I raise this? Well, next slide, Vincent. Here's why. Because I think that as attorneys, we have a duty to know what it is that we are collecting, right? When we are wearing devices. This is the Fitbit. This is the Fitbit privacy policy. I'm the privacy nerd on the phone today, here with you today. I'm not an IP lawyer. I'm a privacy cybersecurity attorney. And one of my things that I like to do in my spare time is read privacy policies, including the Fitbit one, right? Now, I'm jumping around a little bit, obviously, because we're talking wearables and I'm talking pacemakers, but the same premises kind of apply. What is it that these devices are, signaling or sending out? What is it that can be collected from wearing them or having them embedded in your body? Well, Fitbit, for example, we're talking here in the privacy policy about geolocation information, right? The services include features that use precise geolocation data, including GPS signals, device sensors, Wi-Fi access points, and cell phone tower IDs. The idea that you could triangulate the location of somebody wearing a Fitbit based on how close they were to a certain cell phone tower. Next slide, Vincent. Same thing for those who might be wearing Oura rings, right? If you're wearing one of those devices to track your sleep or get sleep anxiety, right? Am I getting enough sleep at night, or things of that nature? Again, those devices are doing things like connecting or collecting location data, and also IP address. Again, being able to triangulate where you are. Next slide, Vincent. Apple, again, location data, and we'll scroll through to the next slide. I'll get even more specific. With Apple, it talks about certain devices collecting very precise location or course location information, including the latitude and longitude within 3 or more decimal places of a particular user or device. So again, as attorneys, we have a duty to understand these devices and the information that they may collect. Next slide. The ABA, when we had COVID hit, put out a opinion 498 about lawyers working remotely. That is one of the few ABA opinions that are out there that really get into kind of some of the technology related aspects of devices. And one thing stood out to me, and that is that lawyers should disable the listening capability of devices or services such as smart speakers, virtual assistants, and other listening enabled devices when communicating about client matters. So again, if we're wearing Fitbits and Apple Watches, we're going into confidential meetings, do we need to be concerned about that? What if you say something like, hey Siri, and all of a sudden, she is listening to you or answering you, or a transcript is being taken? Are we thinking about those things? What you may be saying, Beth, it sounds like you are wearing tinfoil on your head, and I might be, but I, again, am a cybersecurity attorney. And for those of you in the room who are really thinking about, these very complex, life sciences type issues, the work that you may be doing is of interest to certain foreign nation states, right? You would love to learn about trade secrets or information in that nature. So you want to be thinking about these devices and how they communicate and what it is that that they may be gathering about you or about your clients unintentionally. Next slide. Again, I actually would suggest maybe, Vincent, let's take the slides down and I'll just wrap up with this to open it up to questions, because I know that we don't have a ton of time. But again, the idea being, when we're thinking about attorney ethics of these wearable devices, is we want to be thinking about what it is that's being collected, where are you wearing it, what are you carrying into a client meeting unintentionally or intentionally. The same thing when you think about medical devices generally, right? What is being collected? What is the risk, the cybersecurity risk of those devices? What are the pros and cons of having them, right? Obviously, when I talk about the Nancy Guthrie matter, and you think about disappearance of some individual, the fact that that pacemaker has a Bluetooth sync, right, or is helpful here potentially to try to find that lady. But at the same time, when you think about privacy concerns and you also kind of overlay that with some of the good stuff that Ceren was talking about with loss of data or misuse of data, it's a very complex question. So
Thanks.
speaking of questions.
Thanks so much. I can take it from there. We have really great audience questions that have come in. I'll start with one, which is, do you all use wearables? And I'll kind of loop that in with another question, which is, what questions should we be asking about the wearables that we use personally?
I'll just jump in and start and then maybe pass the mic as the cybersecurity attorney in the room. I do use a wearable on certain occasions. There are certain incidents and certain matters where I will remove devices or wearables from those sensitive settings, because I do work with defense contractors and do work in critical infrastructure in the energy sector. So in certain settings, I will not take a wearable in, or, for example, bring in perhaps even my iPhone, right? Because again, of certain national security concerns. But I'm curious to hear what others think too.
Yeah, similar. And Beth, I'll sort of double down on that. We're starting to see concerns in certain sensitive professional meetings, like board meetings, about having wearables, particularly like smart watches, that are monitoring speech patterns, what's being said, et cetera, in addition to even phones if they're on certain settings, or our smartphones. So we're starting to see boards of directors, board meetings, and other sensitive attorney-client settings where we say, leave the devices outside, don't bring them into the meeting. Not even a matter of turn it on, turn it off, disable this, that, just take it off, leave it outside.
All right, let me just echo that, because the permission, the US is a opt-out and the European model is opt-in. In other words, you can control in Europe whether your information is going to be available. In the US, it's part of the T's and C's. And what are you going to do about it? The easiest way to control it is not to use it. But then, of course, it does you no good. If you're out on a run, it's very useful. If you're in a meeting, it is not. So you have to control when and how you're using the darn thing. That's what I had.
All right.
Yeah, go ahead.
Yeah.
No, I was
No,
gonna
no,
say I use it, but I work in less sensitive environments, I guess. So, but I, as a personal user, I now actually pay extra attention to what I'm consenting to or not every time I check a box somewhere, because as Stan said, it's an opt-in, opt-out difference that, maybe consumer agency is a little bit required nowadays, especially in the US. So.
Awesome. We had several questions come in about AI that I'll try to loop in together. I read a stat the other day that 45 million Americans will ask ChatGPT a health-related question this week. And that might have implications both. Is that going to be, if that is integrated with wearable technologies, or is that going to be regulated in a way similar to wearable technologies? But also on the other end of that, will AI make the privacy concerns more palpable here, in that it will make it easier to potentially identify people or to kind of magnify privacy concerns?
All right, let me lead that one off, because the issue with AI is not the sky is falling, but Houston, we have a problem, and a big problem, because yes, AI is useful, and keep in mind that AI is not terribly intelligent. Despite the moniker, it relies on the data it takes in, and if it's your data, you want them to do that. So you have to be aware of what on earth is going on. That's what I had for the moment. Anyone else want to chime in?
And just to say, not necessarily, I think there are HIPAA concerns, and that users, and I would caution you as users to be very cautious about information that can be put in, kind of behavioral profiles that can be made based on questions that you ask, right? What you're consenting to. The other thing I will footnote is that yesterday, the Southern District of New York, in U.S. versus Hepner, the court there said that a individual waived the attorney-client privilege by putting in information into ChatGPT that his lawyer had provided to him, and it was in a criminal matter. But the court has come out there and said, listen, by putting that privileged information into this particular setting, you have now waived the privilege on those communications. And so I think you have to be really careful, not just in the health context, but also in the privilege context. So we're going to see a lot more decisions come out around those issues.
Yeah, and that's a great point, Beth. And adding to that, I'm involved in a matter in which CEO of a company used one of the frontier generative AI models to do some prompting, and that's resulted in a deposition, a very awkward deposition, as well as interrogatories exposing the prompts and the responses to those prompts. So none of that is privileged in any way, and it could be very compromising to parties, including powerful and
Exactly.
One other thing I would mention with health information is the notion of de-identification. And for the students, don't be too confident about de-identified information remaining de-identified, particularly with AI. It's becoming more and more possible to re-identify information that at one point was thought to have been de-identified. So, whatever you put into your frontier large language model, if it's, outside the firewall, if it's, you're just accessing through the internet, you should put it in with a full expectation that your identity will be associated with that information or can be reassociated with it, and that it'll be used and potentially regurgitated to others in open public.
And to the earlier question about wearables and AI intersection, it is already there. If you're using it like Oura Ring, for example, because I do have one, it actually personalizes, it literally says AI-based findings based on the information it collects, and it asks you actually to connect to other data that is collected through other means that I am wearing. So the platform and the technology is there, and the product is already there. Now the question becomes, what does the liability out of that information, right? If you actually take an action out of that based on that suggestion of my Oura Ring, for example, what is the liability to the company? What is the liability to the third party that you're using, in addition to the information that is being shared? So it's already here to that question, and we all need to just be cognizant of that, I think.
Let me add that AI will make assumptions where there are gaps in its knowledge base, and there will be gaps. And we probably know those assumptions under the term hallucinations, and they are there. So there may be stuff that is being looked at that is simply dead wrong. And how do you know? You don't. That's what I had.
Amazing. All right, I'm being flashed the show lights here because we have a class coming in after us. But thank you all so much thank you everyone for attending. Thank you to our amazing speakers for all of this. And I hope everyone has a good day.
I will add that I think we're all going to be available for questions afterwards. Just our email addresses are in the slides. So if you've got questions, maybe we've got answers.
Sounds great. I'll share those email addresses.
And thanks, Vince, for arranging this, and thanks to all the students.
Yes.
Of course.
Bye,
Thanks. Thanks, everyone.
Bye-bye.